Administrative law includes the laws governing the administration and regulation of state and federal government agencies. Administrative law falls under the executive branch of government. The legislative branch delegates rulemaking and rule-enforcing authority to agencies. Congress may also call for the creation of a new agency. The judicial branch steps in when either an agency acts outside of its authority or when Congress grants an agency authority outside of its scope. Administrative law reflects the concerns of the times. For example, the growth of federal administrative law took off in the early 19th century in response to the issues faced by an increasingly industrialized society. It peaked again as Congress created agencies to implement New Deal programs to bring the country out of the Great Depression. And again in the 1970s, agencies were created to address growing environmental and health concerns. From the end of the Civil War to 1900, 6 federal agencies were created. Between 1900 and 1930, 17 agencies were created. In the 1930s alone, 18 new federal agencies were created to implement Roosevelt's New Deal. There were concerns that so much administrative activity was creating a 4th branch of government, so in 1946, Congress passed the Administrative Procedures Act. This act standardized the process of agency rulemaking and adjudicating and provided for public participation in the process. Additionally, the APA stipulates that agencies keep the public informed of their procedures and rules, and it defines the scope of judicial review. Congress can create a new agency by passing an organic statute. For example, the Federal Food, Drug, and Cosmetic Act of 1938 granted regulatory authority to the Food and Drug Administration. Enabling legislation grants authority to an agency to carry out certain duties, such as rulemaking, adjudication, and enforcement. For example, the Bioterrorism Act of 2002 authorized the FDA to prioritize inspections meant to detect deliberate tampering with imported food. Congress tasks agencies with working out the details of enforcing the law. Agencies may also be called upon to define terms used in the enabling legislation. Congress can only delegate authority to agencies within the limits of the Constitution. Judicial review may be used to determine if an agency has acted outside of its authority. These cases are usually heard by district courts, but may also be heard by appellate courts or the Supreme Court. Agencies exist outside of the executive branch, but they are organized under it. At the federal level, members of the President's Cabinet serve as the heads of the 15 executive departments. As an example, let's look at the organization of the Department of Justice. Originally, the Office of Attorney General was a one-person, part-time job. In 1870, Congress passed the Act to establish the Department of Justice. The Attorney General is the head of this department. Since 1870, other staff positions have been created to assist with the department's 60 agencies. And you've certainly heard of many of these agencies, like the FBI, the DEA, or the U.S. Marshals. So as you can see, the Department of Justice is responsible for many other agencies. Each agency has either its own website or a page linked from the department site, www.justice.gov. Like statutes, regulations are primary law. Regulations take care of the details. Take USDA organic labeling, for example. The U.S. Code says in order to be certified organic, food must be grown without the use of prohibited substances. And the USDA regulations define what those prohibited substances are. Once an agency is given the authority to promulgate regulations, they first have to decide if any regulations are needed. If so, proposed regulations are published in the Federal Register. The public is given the opportunity to comment on the proposed rule. The agency reviews public comments and may revise the proposed rule in response. Next, the final rule is published in the Federal Register, and finally, the regulation is codified in the Code of Federal Regulations, or the CFR. Agency websites are valuable to your administrative law research. Each agency is independently responsible for their own website, so usability and presentation of information will vary. You may find it helpful to contact agency staff, especially at the state administrative level. You can find contact information on the agency's website. You can also find agency history, including organic statutes or other enabling legislation. Also, be sure to watch the agency's website for news of current regulatory activity that may be relevant to you or your clients.